We can't talk about competency and not talk about Dusky versus United States. So, this is the story of how the U.S. started coming up with competency trials. So let me be clear. There was competency to stand trial cases before Dusky. However, there wasn't a clear constitutional standard for it. This was the first one that was like clear, cut, and dry. The courts had long recognized that someone who hadn't understand what was happening in the court shouldn't be tried. The old phrasing was that a defendant had to be able to plead to the indictment and understand the proceedings. So what made Dusky versus United States so important was that it was the first time in U.S. history with the Supreme Court that it laid down a clear and modern test for competency. Tracking? All right, so we got this guy named Milton Dusky. So this guy named Milton was convicted of serious crimes, okay? But the questions that were raised within the court system about whether he was mentally competent or not came about. They were thinking, I don't know if he's mentally competent to stand trial. So the main issue of the trial was determining what constitutional standard must courts use to determine if a defendant is competent to face trial. Ultimately, it went to the Supreme Court, and the court held that due process does require a competence evaluation before trial, specifically competence including two core requirements. What are those requirements? 1, the defendant must have a present ability to consult with their attorney with a reasonable degree of rational understanding. I always use Taylor Shabusiness, I think it's her first name, as an example. She had a competency trial done, I believe. So if you're trying to figure out why somebody would have that, kind of look at her case a little bit and how she was acting and just what she did allegedly in the crime. Well, I guess she's convicted now. What she did in the crime, and you're going to be like, huh? 2, the defendant must have both a rational and factual understanding of the proceedings against them. So this means if I am the lawyer and you are my client and you come to me and I'm like, listen, you have to be able to you have to be able to participate in the trial. We have to be able to talk about your case. Like, I'm going to go to the jail. I'm going to meet with you. We're going to talk, blah, blah, blah. If you're like, dude, I am God. It doesn't even matter. I am talking to purple elephants. Like, just completely out there. And obviously there's more evaluations that go into this because how often than not do people try to lie and say they're seeing purple elephants? There's got to be a lot of evidence to back this up. However, you have to be able to participate in the trial. If you're not like coherent at all and just completely in left field, most likely you're not going to be competent to stand trial. Doesn't mean that something's not going to happen and you're not going to be able to go to trial and someone else represent you, but you're not going to be able to participate. So with Dusky versus United States, the case was remanded, meaning sent back to the district court because the record did not adequately support a finding that Dusky was competent. The lower court had not used the correct standard. This matters because Dusky established a benchmark for competence to stand trial in the U.S. law. It shifted courts toward assessing not whether a defendant knows what's going on, but whether they can meaningfully participate in their defense and understand the process in both factual and rational terms. If you're going to study forensic psychology, this is one of the cases that you guys are going to study, Marion. I've gone over this, I think, almost every single semester. This is different than going to court to see if somebody's legally insane or NGRI, not guilty by reason of insanity, blah, 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 blah. This is literally just seeing if you can participate in court.